So yeah, I think that change you just mentioned that they've put in, that's something that any right-minded company would be doing anyway, though, isn't it?
You would hope so. You would hope, but at the moment, for most people in bereavement, you'd have to get yourself signed off sick. Whereas this is a way to stop that. So they're obviously entitled to that 52 weeks of unpaid leave. Obviously, depending on their personal circumstances, will be depending on whether they can take that unpaid leave, because it is unpaid. So it might be, if there's no life insurance or there's nothing financial in place to support them, that those employees aren't able to take any unpaid leave if their partner dies.
I didn't twig that bit. So the bereaved parent paternity leave is unpaid.
Yeah, it is. There's no statutory pay linked to it. So whether that will change in the future, we don't know. And normally for a statutory entitlement, there is statutory pay linked to it. So whether, like we have bereaved parental leave at the moment, and there's 2 weeks of statutory pay linked to that. So whether in the future that changes, we don't know.
Well, from an maybe I've worked only at good companies, but every company I've worked for would look after you in that scenario. But I know not all would they?
No. Unfortunately, there are companies out there that do need the government to tell them what to do.
Gosh.
Okay. Well, I think we're 2 or 3 minutes in, so we will. I've got that there in case I need it. Yeah. Okay. We'll get started. So, welcome. Thanks for joining us. This is the Employment Rights Act 2026 live Q&A. So basically, we're going to go for about 30 minutes. We've got the 5 biggest risks coming as part of the Employment Rights Act change. I've just introduced people first. We've got my colleague from Farnworth, John, Strategic Director, experienced litigation and solicitor of many years, running different businesses. So you're here in that capacity as a business leader, former business owner. And Louise and Micky from JaRo HR. Tell us a bit about the company, Louise and Micky.
So we set JaRo HR back up in 2020, so in December 2020, in the height of COVID, because we knew then that businesses, they needed good HR support. There was a lot of information out there that no one knew how to decipher, and we wanted to be able to provide businesses with the support that they needed and deserved during that time. And 5 years in, we're still going strong and still supporting local businesses. So it's our goal to make sure small local businesses understand employment law without the jargon.
Nice. I mean, the topic is something which has, I'm just going to knock that off, get us bigger. Caught a few people like that I've spoken to. So when I found out about this topic at the start of the year, when I first met you guys, it was news to me, but I'm not a business owner, just an employee. But John, from a business owner point of view, sort of what take us back to when you found out about the change. What was your reaction?
Yeah, okay. I mean, just by way of introduction, I'm John Batchelor. I'm the Director of Strategy here at Farnworth Roads. I am a lawyer, which I do try and keep quiet. I'm certainly not an employment law specialist. I'm kind of here in the capacity as a business owner. I've owned and led my own businesses for the last 25 years. I've acted as a consultant to many other businesses in that time at board level. And I'm coming at this from the angle of, you know, how am I feeling about it, and how should we be feeling about it? And when I first heard of this act, I felt it was kind of part of a wider picture. You know, as business owners and leaders, during the course of this parliament, we've seen quite a lot of costs piled onto us, increases in minimum wage, increases in national insurance, increasing costs generally. And I felt it was kind of part of a picture where the pendulum's swinging from employers going through more into the realms of employees. And I still feel that about it now. But when I first heard about it, I didn't really appreciate the extent to which this can impact on employers, the significance of the changes that are coming down the line, and the risks that that those changes bring with them. And the risks to us as business owners are very significant. with this set of changes. It's the most wide-reaching set of changes I can remember, certainly course of my time in owning businesses. And I would say the biggest swing away from that pendulum, away from the rights of employers into the rights of employees. And that's the landscape we're working in, so we have to deal with it. Overall, my view is it's all contributing to making life for employers more difficult in terms of being able to run profitable and sustainable businesses, which enable us to offer roles to great employees. But really, until I started to talk to Louise and Micky about the detail of the legislation, I hadn't quite understood the extent to which this may cause problems and the potential for it to cause problems. And some of these changes are very wide-ranging. They're starting now. In fact, I've already started some of them, but they'll stretch over the course of the next 12 months or so. And it's important that we as employers understand the landscape that we're working in, and then understand what we can do to try and mitigate some of the risks that are coming down the line. And those risks relate not just to how we are as employers, but they're financial risks for us. Going from increased SSP up to ultimately unlimited damages on unfair dismissal claims, potentially reputational risks, looking at things like the shift in burden onto employers in relation to sexual harassment claims and things like that, some of which we're not going to go into today, but it's important people understand how the extent of these changes that are coming and the ability of employers to recruit and keep a stable and hardworking workforce. So there's loads of risk in all this. And until you get into the nitty-gritty of the detail and start to understand what the risks are, what the changes mean to how we operate and how we can mitigate some of those risks, it's very difficult to really understand the extent to which those risks exist, but they do. So today for me really is about Louise and Micky as the experts in the field, because I'm certainly not, being able, us as business owners, to understand more detail in relation to some of those risks and understand what we can do to mitigate some of those risks. And to me, I'll be honest and say, perhaps I haven't always taken the HR advice that I've been given as a business owner in the past, and I have been willing to take a more broad brush approach to things and go, we'll sort it, it'll be right. I'm afraid with these risks and the changes that are coming now, we all have to move away from that. My thinking about where we are in terms of risk now is we need solid foundations in place, good contracts, good policies, the things that enable us to prevent risks from happening up front. And then where we need it, we need to take expert advice and make sure we've got that advice on tap. And so that's why we're linking in with JaRo HR and hoping that ourselves and our client base can benefit from that expert advice, because the harder it gets, the more we need the experts. So that's my kind of overview of the whole thing.
Yeah, exactly. You're right, John. I mean, I think this is the most changes we've ever seen in any one time. I think there's 11 alone this year. We're not here to punish employers, but they will do if employers are unprepared. Yeah,
that's the thing, that when we've been talking about this to different people, either in my network or businesses next door, so around the estate. The first one that I want to dive into is SSP from day one, statutory 6. But I think there's a couple of things with this. I've seen in media coverage picking that up as great, sick pay from day one. But I don't think employees, or 99% of employees, realise that the business foots that cost. Yeah. And when I've spoken to small business owners, I know the costs add up on that when you're in certain industries. So if you've got, take hospitality, flaky staff, they fancy a day off, suddenly the business has got to pay for that. We all know that person's not sick, but how does a business manage that? Because then at the end of the day, I think what you were coming to, John, that pendulum ends up swinging all the way the other way, that business gets punished, and then in turn the respectful employees, the ones who want to contribute to a business, actually end up footing the bill at the end of the day because there's less money in the business pot. So SSP, take us through that. What is it? Tell us what's changing. Why is that a risk? And then what's your tips for handling it?
So currently, when an employee goes off sick, there's what we call 3 waiting days. So the first 3 days of any sick period is unpaid, and then they're paid SSP from day 4. Taking into consideration any company sick pay, obviously what we're saying here is that there's no company sick pay in place. We're just looking at SSP. So currently 3 days no pay, and then paid from day 4 on the SSP rate. From the 6th of April, that's going to change. So that will be paid from day one of sickness. So anybody who has just 1 day off will be entitled to SSP for that day. Also, at the moment, there's a lower earnings limit in place. So certain people don't meet the criteria to claim SSP from their employer. From the 6th of April, everybody will be entitled to statutory sick pay. So it'll either be 80% of your average earnings or the SSP rate, which is £123.25, whichever is lower. So that's the lower amount the employer will pick. The impact of this is those employees that have just the odd absence here and there, or they've gone out on a Sunday night and they're not ready for work on a Monday morning, so they're calling sick, whereas those days weren't paid by the employer. So when cover needed to be put in place, there was no penalty to the employer. Now they are going to need to be paid. So the employer will have to pay for that day plus the cover that they put in place. What's really important now is you have a robust sick pay policy in place and sickness policy and absence monitoring policy in place, because what you want to do is ensure that employees are aware of what will happen if they do have frequent absences. The first step is to ensure that all employees are making a phone call to call in sick. The worst ones we see is where employees are allowed to WhatsApp in or text in, and anybody can easily send a quick text and say, I'm not in today. It's easy to say that when you're not having to pick up the phone and speak to your manager.
Yeah.
And then the next step is making sure you have really robust return to works in place. So for every single sickness absence, the employee comes in and they meet with their line manager and go through the reason for their absence. That will stop the employees that aren't genuine, because they won't want to come and sit in front of their line manager and explain why they were off. After that, it's important. Oh, sorry, go on, Paul.
No, go on. I think we're going to say the same thing.
After that, it's really important that you have trigger points in place. So whatever you use within your business, whether that's the Bradford factor or specific trigger points for the amount of absences that are had, it's important that you follow those. Obviously, we have to make allowances for disabilities and making sure that those people that can't meet the trigger points because of a disability, that we're putting flexibility in place. But in general, having those trigger points mean that you as a business know what's expected, but also the employee knows what's expected of them. And when those trigger points are hit, it's easy then to have those conversations with the employees and say, this is the policy, these trigger points have been hit, and this is the outcome.
I think, yeah, just building on that, I think it's a two-way dialogue with your team, with your employees, because somebody will have, you mentioned disabilities, I was thinking more perhaps like children are sick, or you just need flexibility in your life, and it's working with your team, isn't it, to understand. But back to educating people that, look, if you guys, a portion of you keep doing this, it's actually going to impact everybody else, and I think there's a good learning exercise. Bad eggs will be bad eggs,
absolutely.
And they won't get on board with it, but
and actually, if you're not managing it, it breeds resentment within the team, because those that do turn up every single day start to feel like, what's the point? So by managing it, it also helps the wider team to see that you are on top of it. And it isn't that some people are allowed to swan in and out whenever they want to. And some people are here. It helps the wider team. I think the key thing what you said there about whether it's time off for your children, time off for dependents, by having those return to work meetings, you can pick up whether it's not genuine absence or sickness absence. Is it something else that shouldn't be being classed as sickness absence? And if it is, what can we put in place to support that employee?
Exactly. Yeah, all sorts. So Louise, parental leave, while we're on that theme, parental leave from day one, do you want us to explain that a little bit, and then how can we handle it?
Yeah, of course. So parental leave, currently you need 1 year's service to take parental leave. This is going to become a day one right from the 6th of April.
What are we talking about here?
So parental leave, it is unpaid, but it's 18 weeks per child up to their 18th birthday. So they can be taken up to 4 weeks in any 1 year in blocks of a week, unless the child is disabled, and then they can be taken in single days. So a lot of employers may think, well, I see no problem here. It's unpaid leave. How's this going to affect me? But I do see there'll be higher operational risk here, because we may see now a higher volume of requests now that people can have it from day one. We may see earlier requests. People could just be in week one of their induction and they're requesting to take 3 weeks of unpaid leave. If you've got small teams, that can have a massive knock-on effect finding cover. If you've got roles that are very specialist, finding cover for them roles can be really difficult, or you're in a high turnover environment. So the risk will also be discrimination if requests aren't treated fairly and consistently. So we've got to think as well, the children, they get 13 weeks of school holidays per year. There's people in businesses that don't have that strong family network. They don't have a lot of support around them. So this will be ideal for them. And obviously then you're going to see requests in them key times, the summer holidays, the Easter holidays, when you already may have a number of staff who are already on holiday. So we really need to plan for this. So it's updating your policies, that it's a day one right, updating your induction packs, your handbooks, planning for these early requests, having backups, especially for them critical roles, and auditing your payroll systems, clear documentation. The one saving grace, Paul, is that employees can delay up to 6 months. So if somebody does put a request in and they are maybe on a time critical project that, you know, if they took this time, that project would not be completed and it would have a detrimental impact on your business, you can postpone up to 6 months. So whilst it is paid, we may see a higher volume of requests with it being a day one right, and you do need to plan and get your cover and backups in place.
And I do think with this one it's not really widely known, parental leave. It's not really been out there, and now it is out there and it is in the media. I think more people will be putting those requests in.
Yeah, currently we've not seen very many, have we? But I think things will change.
I think my experience is, and having looked back over the last 25 years, people are very much more aware of their rights.
Correct.
And I think as employees, we just have to work on the basis that whatever rights have been put in place on behalf of employees by the government, people will use them. And, all we can do about that is mitigate and set businesses up properly to be able to cope with absences more than they've been doing so far.
I think that's thinking of the people who might use this from day one. I think that's the other thing to mention, is to try and expose that in the interview process. If it's a good person that you want to hire, I think it's a good way to try and work that out somehow in your interview process. Have you any thoughts on that, Louise and Micky? Because you might want to
step in there and say absolutely not.
Be very careful. Be very careful.
Say in the interview process, do not talk about family, childcare, anything like that. You'd be teetering on the edge of discrimination if you did, and then decided not to offer a job to somebody who didn't have, or it would be discrimination if you decided not to offer a job to someone that had children. So those conversations.
I was thinking. Fair enough. I'll just for clarity, I was coming at it from the other point of view of like, Louise, you're a great. We really want you. Is there anything else we need to know about, or any special circumstances we need to accommodate? And more from an accommodation point of view. But I fully get what you're saying. Yeah.
This is a great example of why we need to take advice from the experts.
Exactly.
And all I'm saying.
And why I don't get involved in those conversations. There's a few other changes, just quickly. Just last couple of minutes on this batch. Sort of paternity changes. Another one's been snuck in at the 11th hour here. But what is the group of paternity changes that are coming next month?
Potentially, there's not that much difference here. So it's just a day one right for you to take the leave. Nothing's changing in regards to statutory paternity pay. That's still going to be the 26 weeks service. As long as you've got 26 weeks service, the 15th week before the qualifying week. So it's complicated, but can be worked out by us or your payroll team. But so it's not statutory paternity pay from day one. It's just statutory paternity leave from day one. So not much is changing there. What has just been dropped on us is bereaved parents paternity leave. So this is if the mother or the primary adopter dies within the first 52 weeks of birth or adoption, then the partner can take up to 52 weeks of unpaid leave. So that is unpaid, and the likelihood of someone being able to take 52 weeks of unpaid leave is going to be small, but it is something that businesses need to be aware of. They need to have the policy in place. They need to make sure that the team know that it's available to them, but also what contingency do the company have in place if that was to happen. Because if someone dies, that employee's not going to have a handover. If their partner's died, they need to be at home with their children. So what contingencies are in place in the business to make sure that role can then be picked up and then carried on for up to 52 weeks?
Like you say, not the biggest risk, but sadly will be a reality for some people. Last couple, Louise, we've got whistleblowing changes. Tell us about that and what your overview advice is.
Just quickly, sexual harassment will become a protected disclosure under whistleblowing. So basically, anybody who puts an allegation of sexual harassment in is protected from unfair and detrimental treatment. So we may well see an increase in whistleblowing litigation. Unfortunately, a lot of business underinvest in training in that area, and particularly around middle managers, and unfortunately that is usually where them cases arise. So just going back a little bit, so currently businesses have to take reasonable steps to prevent sexual harassment. The new legislation is we have to take all reasonable steps. So that one little word is massive, actually. We're basically saying some steps is not enough. You have to do everything within your power to prevent sexual harassment in the workplace. So we're looking at robust policies that are reviewed regularly, that discuss what is your stance, what action you will take, what measures you will put in place, signage in your workplace, messages on your answer machines, even on your footers of your letterheads, how you will tackle sexual harassment, making managers accountable and training.
And this isn't big corporate machines. This isn't just...
This is everyone.
Everybody.
Yeah.
This is everybody. And you are going to be held liable for third-party sexual harassment. So if somebody comes into your business and sexually harasses your employee on reception, you will be liable. If somebody comes into your pub and sexually harasses your staff behind the bar, you will be liable. So it's looking at what action you will take and your policies will detail that the first time, if it's something minor, they'll be spoken to. The second time, they will be banned from the premises. The police may be called. So people need to be all over this. The risk I see is how your managers react and respond to these allegations. So it's updating your policies, ensuring your managers know how to deal with investigations and conduct thorough investigations. It's basically ensuring they are equipped and get your managers trained to deal with these matters.
I think
it's a really hot topic, this one, at the moment.
I was going to say, it's the key takeaway there, I think, educating your managers or your senior people, probably all your team to some respect, and not losing the main sight of that change, which is exposing and weeding out sexual harassment. But again, it's working with your employees, isn't it? But also, I think a lot of business owners would want to do the right thing there anyway, but it's now having the policies.
I have dealt with a sexual harassment investigation in my time, and at the time we dealt with it, I'm going back a few years, we didn't feel the need to involve employment law specialists early on in the investigation. And I've got to say, with these changes, that's the first thing I would do. I feel it's so easy to get this wrong now. It's important that from the outset, in terms of these investigations, employers are doing the right thing. And I appreciate what you're saying in terms of preventative measures to get policies updated and all that stuff in place. I just feel some of this is so easy to get wrong. And we first started talking about this before Christmas, if you remember, and we started talking about Christmas parties. And the risks coming to employers as a result of these changes are very difficult to deal with. So you can get your policies right, but actually how you conduct any investigation and what you do as soon as an issue arises is really the crux of whether or not you're going to be doing the right things. And so take some advice is my advice.
And what's the timeline on those changes we've discussed so far? These are all this year?
Yeah, this year.
And then there's some other changes coming. So let's look at the second risk that was in the mitigation pack we put together. So Louise, we've got the unfair dismissal qualifying period dropping to 6 months. Talk to us about this. John mentioned this is a biggie for businesses.
Yeah, this is what a lot of people are talking about. So in January, it will drop from 2 years to 6 months. But employers need to be aware it is not just people coming in January. It's people who have 6 months service at January. So you need people you are employing now. You need to be prepared for that. So
what's the maths on that? That's people employed back already.
Well, it's now because anyone now would have that 2 year qualifying period, but from January that 2 years been removed. So you probably go backwards a bit from now and think of the employees you've already recruited and then those that are starting going forward. So from January, after 6 months, that they will have unfair dismissal rights.
Yeah. So your probation periods are key. Most companies use 3 months to 6 months. A lot use 6 months because it gives you that. 3 months isn't often long enough to review somebody's, but the 6 months are not going to work, because if you're waiting till 6 months to review somebody's probation, they have got the rights from fair dismissal. So
what can we do though?
We need to be changing our probation periods. We are advising 3 months. So if your probation period is 3 months, at least then it gives you a couple of months. If you're not just sure, you can then extend the probation period, but it also allows for your notice period as well if you do decide to terminate. So it is so crucial we get these probation periods right. We always advise midpoint reviews. So don't just wait until the 3 months. Be having a review halfway through. Have your clear job descriptions with your clear expectations, KPIs. Be sitting down and holding these reviews. 1.5 months in, if there's issues, let them know what they are. Training, support them, because we want, obviously, this employee to be successful. It is really essential. Your managers are accountable. It's no good now if, oh, sorry, I forgot to hold the probation review. They need to be accountable and holding these meetings. Also, look at your onboarding. It is hard. I'm not going to say it's not. Getting that right person, people can be brilliant at interview, and then when they get into the role, they're not. But try and improve your screening. Look at gaps in CVs, your interview techniques. Get people back in for a second interview, a second pair of eyes. Maybe bring tests in, practical tests, and follow up on them references. A lot of employees are going to think this is great, but I see another side as well, that good people are potentially going to lose their job, because sometimes I think it's going to get to 3 months and a lot of employers are going to be like, not sure. They're going to go down the road. Whereas I've seen people who are given that extra few months when somebody's not sure, and then they've really just grasped it and become a really good employee. And I think we're going to potentially lose some good employees because employers are going to be scared to give them that little bit longer.
I think this will. Do you think this will impact sort of mid-level hires more? So like entry level, you're going to have a lower runway expectation anyway, and probably senior level, you probably already know them or know what to expect. But that middle layer is probably going to be more impacted by this, aren't they?
Yeah, absolutely.
Yeah.
And a lot of times when you go into a new business, it takes you 3 months to get your head around
Yeah.
the job.
Yeah.
And so I think it's going to affect more people than we realise. And I completely understand 2 years was too long. And I think that isn't fair, getting to 20 months into employment and it being wiped underneath you if those conversations haven't been happening. But I think 6 months is too short. I think they've missed probably the sweet area in between there.
John, what are you going to say?
I think that point you just made, Micky, about how you onboard people is really important. We've put an enormous amount of effort into how we get people to understand their role and be able to perform that effectively as quickly as possible as they join the business.
Yeah,
It's all right us as employers going, well, we'll do a review in 3 months' time. But actually, we've got a responsibility to our team. You know, we need to make sure that they understand what it is they're supposed to be doing in their role, and they've got the tools, skills, and support to do it. And actually, I'm finding we are, as a business, seeing some big benefits from that crystallizing quite quickly, because people settle in quicker, and therefore they've got a better chance of achieving. You know, so actually, some of the mitigation around these risks isn't just to do with policy and all that; it's actually to do with how we operate as a business.
Absolutely.
And it will have a knock-on effect that, you know, if employers panic and let this person go, it's then your recruitment costs again, isn't it? If you're going back to a recruitment agency, you're paying for an advert, your time shortlisting, interviewing, training, inducting.
Well, don't forget,
it's a massive
you're hiring
cost.
for a reason as well. So that good person you're trying to support might go, stuff this, I'm off, because you're not getting the right people in. So it snowballs, does that. There's other risks as well that are all in the pack. Compensation cap being removed, extended tribunal time limits for people to come back with claims, and then some flexibility being removed around 0 hours. So I think that's going to be applicable to a number of businesses. Do you want to just pick out some ways to mitigate that?
At the moment, we're not. We haven't got the key legislation to that at the moment, so we don't know exactly what it's going to look like. But what we do believe it will be that if you've got you work the same number of hours week in, week out, you'll be entitled to a permanent contract rather than being on the 0 hours. Originally, it was going to be that you will be given a permanent contract, but now I believe it's changed so that an employee can refuse that permanent contract, because some employees like the flexibility of these 0 hours and they want to be on that contract. So what that is for employees is thinking about, what are you hiring for and what do you really need? And if it is somebody consistently working the same hours each week, then it's not going to be a 0 hours contract. That's going to be a permanent contract. And if it is something that you require flexibility for, it's just being mindful that that flexibility is in place and it's not always the same hours every week. It's not the same shifts that are being offered, so that everybody, that 0 hours contract can then stay in place.
Mick's dropped a comment in. I've just seen it's a useful discussion from a business owner point of view. I think that's what you were saying, John, sort of looking at it. Nice to see these topics covered from a business owner point of view. Yeah. So Louise and Micky, I think a few questions just to wrap up as we reach the end. So I think one question I got asked when promoting this was, this doesn't apply, this only applies to bigger businesses. These laws won't apply to me, but that's not true.
No, absolutely not. As soon as you employ your first employee, these rules apply to you. So
right, from employee one as well.
Yeah, absolutely. Everybody is entitled to a contract from day one of employment. And your employee, whether you've got 1 or 500 employees, all of the statutory entitlements apply to them. Now, there might not be that you have to technically have a physical policy in place for everything under a certain amount of employees, but from our experience, it's important that you do have those policies, because how do your employees know what is expected of them, and how do you manage your team if you haven't got those policies in place? You're going in blind. So it's really important that those policies, as soon as you get your first employee, that you set out your expectations, your onboarding, your policies, your contracts are on point, so that from both aspects, the employee and the business owner know how to manage each other.
It's a really good point, because we are still seeing and hearing them comments that, well, I've only got 4 people. I don't need contracts. I don't need a handbook. You know, a contract, like as Micky said, it is a day one right.
Well, I remember when I first met you and I told you about someone I know who hires, fires, does rotas all in a WhatsApp group, and I think your head was in your hands.
The thing is, it works until it doesn't, and the risk only comes. So we only tend to be brought in when there is risk there, when something's happened and we're looking at tribunal papers, or there's been something significant that we need to get involved at. It's so much better for us to be involved earlier on to prevent that from happening, because that saves the employer cost, stress, so much that getting us in early and getting those things in place is so important. So
we've not scratched the surface of what's changing with the Employment Rights Act. I think we've looked at 4 or 5 of them in total, and briefly looked at, summarised how to mitigate them. So practically though, next steps, we've got the SSP calculator. If sick pay is a big rate in your business, you can get an estimate of the cost there. We've got the mitigation checklist. You may be here and aware of this event because you've used those things. Something we've not talked about is the actual paperwork that does get put in place. You've alluded to it. Now, you've put together, or we've put together, John, Louise, Micky, you've put together a pack there of solicitor-approved business documentation. Tell us about what's included, and there's a chance to get some consultancy off you guys, Louise and Micky, isn't there?
Yes, we've included a basic contract. As we said, it's a day one right. So it's got all the standard clauses in of pay, probation, mobility, notice periods, short time layoff. We've also included all the key policies that a business needs. So we've got a pack of family-friendly policies, which we've touched on quite a few of them today: the paternity, parental, maternity, adoption. We've got the flexible working policy, which flexible working is a day one right. Whistleblowing policies, dignity at work, grievance, disciplinary, sickness absence policy. So these are all the key policies and procedures you need as a business owner. We've also included in there a new starter checklist. This is so important. You get it right at the beginning. You obtain all the key documentation you need. For example, right to work checks. We're still seeing employers are not doing these. Their penalties are massive. You need to get that proof that that employee has a right to work in the UK, whether it's through a passport or a share code. medical details. We need to know if people have a disability, if we need to make reasonable adjustments. So that new starter checklist is a really useful tool. We've also included a return to work form because, as Micky said, SSP is becoming payable on day one. So it's important you deal with your sickness absence promptly. Return to works are so key. We touched on those odd people who sickness isn't maybe genuine, and when you've got to sit in front of your manager and do a return to work meeting, it's not just as easy if you are porcupines. And also they're great for spotting patterns. If it's always the same reason, food poisoning, if it's always a Monday, always a Friday. And as you touched on, we're also going to include an hour free consultancy with that pack. So, you know, we can get into the contract, discuss that more, how you tailor that contract, how you can make it tailored for a senior member of staff with restrictive covenants, garden leave. We can train you how to conduct a return to work because they're so crucial you get those right. So these documents will keep your business legally compliant. There
we go. So I was just going to say, you took the words there, and I said legally compliant. They're not. You know, you're not asking ChatGPT, you're getting expert sort of drafted and solicitor-approved wording in your documents. And that helps you avoid all those pitfalls you guys talked about. So we've run over a couple of minutes, so I'm just going to wrap that up. I'll put the link to get that pack and the details for that 1 hour's consultancy to everybody who's registered ahead of time. And obviously we'll get this recording out to you guys as well. If you've got any questions and you couldn't make it, please just send them through and reply to me when I send these through. But thank you, John. Thank you, Louise. Thank you, Micky. It's been really insightful for me learning all about this throughout this campaign. So any last advice for businesses?
Take advice.
Take advice, yeah. Okay, that's the advice. Well, thanks for joining us, and we'll keep these updated. We'll share any good questions we get through as well. Thanks a lot, everyone.
Thank you.